In this episode, we're looking at 3 separate probable cause hearings presided over by Judge David Fletcher of the Harris County Criminal Court in Houston, Texas. A probable cause hearing is an early-stage proceeding that usually happens right after someone is arrested, especially if the arrest was made without a warrant. Under Article 15.17 of the Texas Code of Criminal Procedure, the law requires that the defendant be brought before a judge without unnecessary delay. At that first appearance, the judge informs the defendant of their rights and then reviews law enforcement's account to decide whether probable cause actually exists to support the arrest. If the judge rules there wasn't probable cause, the defendant must be released immediately. Our first hearing took place on November 4, 2024, and involved Raquel Rodriguez, who had been charged with driving while intoxicated just days earlier on October 28, 2024.
Yes.
Okay, Max, who do you have here?
Raquel Rodriguez.
Rodriguez. Vic, you ready? Okay, this is page 20.
Rodriguez on page 25.
All right, Ms. Rodriguez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge.
Okay.
The officer initiated a traffic stop after observing the defendant's vehicle traveling 94 miles per hour in a 65 mile per hour zone. The officer observed an odor of an alcoholic beverage, and the defendant admitted to the officer that she had 2 drinks. Standard field sobriety tests were conducted, HGN 4 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The DIC was read and breath was refused. A blood search warrant was signed and executed.
Felt like that went really fast. So the stop was for speeding.
For speeding, yes.
Then
And then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank 2 beverages.
just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
I know that while the SFSTs were, this is for the Jams, while the SFSTs were being conducted, she was not understanding, like the officer had to explain, I think at least 4 times, the instructions for the walk-in turn, the one-leg stand. He also noticed that I think she took off her boots for the one-leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, just an odor, not even a strong odor at that, you know? And then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? You know, there's no accident here. There's no... is she a Spanish speaker?
I believe so, Your Honor.
I don't see any indication of that.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her, I mean, which is per,
But I get the SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough. An odor of alcohol in and of itself is insufficient.
Yeah.
It seems that this stop occurred at 2 a.m. and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period between when she's finished drinking and then
alcohol dissipates every 1 hour. An alcoholic drink dissipates from your system.
She still had the odor in addition to that statement.
All right, I'm going to find no probable cause.
Yes, Judge.
Ma'am, be careful, really. Every single day, someone dies from a DWI in our county. It's so easy to take a $20 Uber, literally push one button. You have a car waiting for you wherever you want to go in this county. Do you understand?
Yes, sir.
All right, please take a seat.
In the Rodriguez case, Judge Fleer ruled that there was no probable cause because the evidence supporting intoxication simply wasn't strong enough to justify field sobriety testing. Under both state and federal law, as well as Article 38.23 of the Texas Code of Criminal Procedure, officers need reasonable suspicion to extend a traffic stop for SFSTs. In this instance, the officer relied only on the smell of alcohol and Ms. Rodriguez's admission that she had 2 drinks, the last consumed 2 hours prior to driving. Judge Fleer found this insufficient, noting that without clear indicia of intoxication, prolonging the stop for field sobriety tests was unconstitutional. Since evidence gathered from an unlawful extension of a stop cannot be admitted in court, the results of the SFSDs were excluded. With nothing left to support the charge, Judge Fleer held there was no probable cause for arrest, and ultimately the state dismissed the case on February 24, 2025. Moving forward, the next probable cause hearing from November 4, 2024, involved defendant Kian Shaw, who had been charged on October 28, 2024, with fleeing from a police officer under Section 545.421 of the Texas Transportation Code, which makes it a misdemeanor to willfully fail or refuse to stop when signaled by law enforcement.
You are Keon Shaw.
Yes, sir.
Mr. Shaw, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 27, 2024, the officer was conducting a routine patrol on Eldridge Parkway when he noticed the defendant's motor vehicle traveling at an unsafe speed, exceeding the posted 35-mile-per-hour zone. The vehicle then began driving in a suspicious manner by making a sudden left turn on the street and immediately parking on the left side of the road. When the vehicle noticed the officer's fully marked patrol vehicle passing, it immediately conducted a U-turn and got back on the main road. When the officer continued to follow the defendant's vehicle, the vehicle again conducted a left turn and pulled into an alleyway. When the officer initiated his emergency equipment in an attempt to conduct a traffic stop, the defendant's motor vehicle passed multiple safe stopping points before finally coming to a stop after traveling 0.5 miles through a dark and empty parking lot.
What was he doing wrong?
With the officer, he was originally traveling at an unsafe speed, exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DMs if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
Nothing's unsafe to me.
And then he began driving, according to the officer, in a suspicious manner, making sudden turns and then stopping on the side of the road and then getting back on the road once the officer passed. So,
Anything illegal with that? You know,
I believe it would just be the speed limit would be the point at which the officer.
it's a conclusory statement. We need to have like a workshop on how to write ORs, man, for real. You know, everything in this office report is conclusory, suspicious, aloysius. You know, is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the.
Sure.
DMs.
Let's do this. I'm going to have them because I want to make sure if we find probable cause that it's really there. All right. So just hang tight for me. We're going to have to do a little deeper dive. If you just mind taking a seat for me momentarily. Okay. 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 So Mr. Shaw, we're back on you. So just because we do so much, I tend to forget everything, you know. You're charged with fleeing a police officer. You're facing up to 6 months in jail and a $2,000 fine. We left off because we were doing probable cause, and I had an issue because it seemed like the cause was kind of conclusory at the time. And do you have anything new?
No, Judge, and I agree with the court.
So, okay, I'm going to find no probable cause.
Dismissing the case.
Find no probable cause. Be careful when you're out there. It's hard enough as it is. Don't give anyone else the power to even bring more, trouble on your life. All right?
Yes, sir.
All right, man. Good luck.
In the Shaw case, Judge Fleer again found no probable cause because the officer failed to provide any specific allegation of how fast the driver was going to justify the initial stop. While Section 545.421 of the Texas Transportation Code does not explicitly require that the stop itself be lawful in order to sustain a fleeing charge, constitutional protections still apply. Under Article 38.23 of the Texas Code of Criminal Procedure, if the stop violated the Fourth Amendment, or Texas law, then any evidence flowing from that stop, including the officer's testimony that the driver did not stop, must be excluded. The Fourth Amendment requires reasonable suspicion based on specific and articulable facts that a traffic violation or crime occurred. Simply offering a conclusory statement without detail is not enough. This principle was made clear in Ford v. State, 2005, where the Texas Court of Criminal Appeals ruled that an officer's claim of following too closely without describing the actual distance between vehicles was insufficient to establish reasonable suspicion. Applying that precedent, Judge Fleer concluded that the officer's account lacked the necessary specificity to justify the stop, and without admissible evidence, there was no probable cause for the fleeing charge. The state dismissed the case that same day. The third and final probable cause hearing in this episode took place on January 27, 2025, when defendant Francisco Cerda faced the charge of engaging in organized criminal activity under Section 71.02 of the Texas Penal Code. This statute criminalizes committing or conspiring to commit certain offenses with the intent to establish, maintain, or participate in a combination, defined in Section 71.01 as 3 or more people collaborating in ongoing criminal activity. The law covers a broad range of crimes, including drug trafficking, robbery, burglary, assault, murder, and money laundering, and in Cerda's case, theft.
The last one, Your Honor, is Mr. Francisco Cerda. He's a custody judge, and I wonder if I'm wrong on his case.
Is that C or an S?
It's the judge.
Good morning, Mr. Cerda. You are charged with engaging in organized criminal activity. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025, the officer was dispatched to a residence in Harris County, Texas. In the call notes from dispatch state, the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male, and the reportee lives on Buchanan Street and has camera footage of it happening. A witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and a felony stop was conducted. Defendant Hentoja was observed unloading items from the U-Haul, ran to the back of the residence, and prevented officers from arresting him. Defendants Lopez and Cerda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions.
Yes, Judge.
I don't even know where to start.
Judge, that's my concern. If you may, I want to just bring some, I guess, some points of argument to the court's attention. The first one, my concern is that, the 911 caller mentioned unknown parties, and then the police officer later mentions them as suspects without any type of articulable facts, believe that they are the specific people that are the individuals that have taken this U-Haul. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the themes, at least under the four corners of the themes, allege that my client was involved with this alleged act.
Remember, so when they start an investigation, sometimes they just don't have everything, and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul,
Yes, Judge.
and they've given a description of a tall, lanky person,
Yeah.
right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Cerda remained in the U-Haul. There's no further information regarding Cerda.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality?
And Your Honor,
Can you does mere presence impute criminality?
No, Judge, and that's exactly right. Texas law says that mere presence is not enough to
Dude,
bring trouble.
I'm with you.
Oh, yes, sir.
But, so,
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have that information. We'd have to await the OR, and we don't have that at this time.
but I'm not going to sit here and hold
Yes, Judge.
someone.
And that's why we defer to the court.
Let's look at what the statute says, because, 7102. A person commits an offense if with intent to establish, maintain, or participate in any combination or in the profits of a combination or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. One is murder, capital murder, arson, yada, yada, yada. Two, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number four, unlawful manufacture, transportation, firearms. Which one are you relying on?
Your Honor, as is pled is that it's pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence and the information in the DIMS, but right now Chief is looking at it.
And Your Honor, if we could just maybe reset it for a week or so, we call the witness. And we have to
Yeah, he's in custody, and I can't, I mean, if he was on bond, that would be one thing, but he's in custody. I'm not gonna hold him just because, compounding it, Casey, is that he's got an ICE hold, so I can't give him a PR bond,
I would just need, I just need a little more time, Your Honor, to dismiss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, by all means, but all right, Mr. Sird, I'm going to find that there's no probable cause to go forward in your case. Just, Mr. Serta, be careful who you hang out with, Okay, all right, for sure.
Judge Fleer ultimately found no probable cause in Serta's case because there were no specific allegations tying him to anything beyond simply being present in the stolen U-Haul. As the Amarillo Court of Appeals explained in Munoz v. State, 2000, a conviction for engaging in organized criminal activity requires proof that the defendant intended to establish, maintain, or participate in a group working together in a continuing course of criminal conduct covering more than one crime or criminal episode. Mere presence during a single incident of wrongdoing is not enough. In Serta's situation, prosecutors alleged only that he was inside the stolen vehicle, with no evidence of an agreement to engage in multiple criminal acts or that the three defendants had any ongoing plan. Without those elements, Judge Fleer determined there was no probable cause, and the state dismissed the charge on February 24, 2025. Together, these hearings highlight why probable cause determinations are a critical safeguard in the justice system. An arrest without a warrant strips someone of their liberty on the spot, often based solely on an officer's account. The probable cause hearing provides the first real test of whether that deprivation is justified by evidence strong enough to survive judicial review. Judges like Fleer, who scrutinize the facts rather than rubber-stamp arrests, uphold constitutional protections and reinforce public confidence that the courts are committed to fairness and impartiality.